Welcome to Looking at Legal Stuff. Today we have 17 hearings, including 4 new updates, with a couple where Mom is attempting to modify the parenting plan and get Dad to take a hair follicle test after his behavior has become erratic and unreliable. Dad proceeds to drag his feet, lie to, and gaslight the court, only to admit to using in the end. He tries every excuse in the book, but will he finally follow through with court orders? Plus, we have bonus hearings from Dad's recent eviction covered by one of the same commissioners. Let's watch.
Christopher Olson and Tiffany Johnson. Mr. Olson, are you in the Zoom booth there? You'll need to unmute it somehow. Is Tiffany Johnson? Oh, there you are.
I'm here.
Okay, great. Thank you. There you go. Mr. Olson, you with us?
Yes, I am.
Great.
Can you hear me?
Yes. So this is a motion for adequate cause. And let me just pull up the file here, if I may. And that's brought by Ms. Johnson, or your current name is Steinweg?
Yeah.
Okay. So Ms. Steinweg, why don't you go first and explain why you feel I should sign an order for adequate cause, and then Mr. Olson can respond.
There's just been a significant change in Chris's behavior in the last year, at least. Chris used to be very involved in Zach's life in general. He would go to sporting events, he would go to doctor's appointments, things like that. And in the last year, he has been up to 40 minutes late picking him up. He's not involved in any of sports, doctor's appointments, anything like that. Zach has come home stating a lot of things about drugs and his dad overdosing. And recently he asked me why his dad would have him pee in a cup for him. Chris has lost his job, and I know that there's some medical issues going on, but that doesn't usually cause you to be late to pick up your child, or I guess stop being so present in their life. So just a lot of concerns, and with summer coming up, I'm concerned that he has him a week on, week off, and there's been frequent times that he hasn't given him his medication while he's there. So I think that basically sums up.
Okay, thank you.
Thank you.
Mr. Olson, any response?
Yes, Your Honor.
Please.
Zach had been in my custody for 5 years and wasn't doing very good at Barn School. In fact, he was like leading the league in office referrals, and wasn't getting like the proper attention he needed that he would be getting in Jewel. Okay, so he moved to Jewel, Oregon, and goes to Jewel Middle School. This is quite the drive. In fact, the road that I have to take to get there is the most brutal, bumpy, windy road I've ever been on. I was late 40 minutes one time. This is winter time, going through a road that are falling down in the road. People bring their chainsaws and chainsaw the road, the trees out of the road. There's snow, ice. It was a pretty crazy winter, and believe me, I have tried leaving earlier and earlier to get there in time. And the past 2 weeks I've done that. I'm still late. 2 minutes late, 6 minutes late. I'm sorry to be that late. The work that's been going on the bridge, I tried leaving earlier, and I was 6 minutes late last time to pick him up. So, and also Zach's sports. I have always been totally, every practice, I've always been like the coach's hand. I'm usually out there with the boys, helping out. I haven't been able to do that. The way they do sports is really different over there, it being such a small school. When his games have went on, I have been able to get to the ones that I could. Now, I did have some issues with my health where I had to use basically all of my vacation time and wasn't able to like just leave work, you know. So I had difficulty getting to some of them. It seriously breaks my heart to not go watch my boy do sports. And enough with that. This declaration that I've read over is just basically like the two before this one. There are a lot of accusations, false accusations in there. I don't know. I know I have lost weight. I did lose my job. I'm working on getting another career going. My body just kind of gave out with doing the welding and the fitting all the years and all the overtime they used to push, and I just couldn't perform the way I used to perform, having to change my career and get into something different where I'm not using my body like I was. Zach, see, to my awareness, we're not supposed to talk about our cases with our children. Our last case, he knew everything that was going on. I don't know who was talking to him because he does have a sister, but he was totally aware of things that they're not supposed to be aware of. He should not even know some of the stuff that is going on right now. It blows me away of how he even knows this. Now I know he's been influenced by my girlfriend's son, whose dad is very, very vindictive, and I've seen, I mean, just flat out lies, just ridiculous, and brainwashing the kid. And this kid says things that a kid that age should not say. I don't know. I feel that Zach is in in a safe place. He always has been. He always will be. Yeah, you know, I'm willing to give the UA. I don't feel like I need to go through and defend myself on all these. You know what? If you want to call my mother, she has a statement from my mother that says some stuff. My mother said I did not say all of that, but I was concerned about your health too. And I understand that. And I don't like to have like people worry about me. My mom didn't know when I got COVID, and they took me to Portland. They took me to St. John's. St. John sent me to Portland. I didn't even let my mom know that I was going through that night, just my girlfriend, in case anything got really, really serious. And it was really serious, but I just don't need her to worry, you know, is how I feel. I don't think anybody knew that I don't think it's any of Zach's mom and stepdad's business that I'm diabetic, that I take heart medication. I quit drinking and I lost weight. I thought I was supposed to gain weight.
Okay.
I don't know, Your Honor. I'm not here to waste anybody's time. Let's just get down to it. I mean, I'll take a UA. Let's like get over this.
Yeah, thank you.
You're welcome.
Ms. Steinweg, any response?
No, Your Honor.
Okay. So neither of you would be aware of this, but the court has recently adopted a local rule where before we take any other action on a parenting plan issue like this, we'd like the parties to go to mediation. That's in certain circumstances, this one qualifies for that. And so I'm going to order that you go to mediation. We will get you the address of the mediator firm. There'll be some cost, but it would be less than appointing a guardian ad litem at this point. It will, if you're able to resolve it at mediation, it will be quicker than setting this for trial and going through a trial. So I've got the order here. The address of the mediation center is at 1338 Commerce in Longview, and it's called the Center for Constructive Resolution and Conversation. I'm going to order that you share the cost, but it's my understanding is the total cost is less than $200. Okay. I'm going to have my judicial assistant, whose name is Autumn, get a hold of both of you and just give you more specifics about how to set that up. Okay.
Okay.
So that is what I'm going to order at this point. I'm going to set a review about 6 weeks from now. I'm hoping that you'll go to mediation and be able to come up with a revised parenting plan. If you cannot, you're not successful, then we'll come back and we will address the adequate cause motion at that time. So today's the 19th. 6 weeks would be about June 7th. So if you want to write down, we'll have a hearing on June 7th at 9 o'clock. And we'll check the status of how the mediation went. Okay.
Okay.
All right.
Thank you.
Christopher Olson and Tiffany Johnson.
I'm here.
You go by Ms. Steinweg now,
Yes.
though, it looks like. Is Christopher Olson here? And Ms. Lawrence, you're on this case? You're muted right now, Ms. Lawrence.
I was finishing up in 2020, but my name was on the docket, so I showed up in case the court needed me.
Okay. Apparently, this was sent to mediation. I'm not sure I signed that order or if another judicial officer did, but apparently there was no cooperation from Mr. Olson with the mediation. Is that right?
Yeah, they even called him and gave him extra time and he still didn't appear. I don't know if you received the letter from them.
I did not receive the letter from them, but I do
Okay.
understand he did not
Yeah,
cooperate.
and he didn't appear at the last court date either.
Okay. All right, well, the attempt was to have both of you determine a parenting plan or a modification to the parenting plan through the mediation process, and that did not work for lack of cooperation. Therefore, I'm going to sign the order for adequate cause. And you had marked on here that no further hearing was necessary. I'm going to change that. I'm going to set a hearing on July 5th in front of me, which will be essentially an order to show cause hearing, which will allow you and Mr. Olson to present evidence as to what the parenting plan should be or what it should be modified to. And then I'll make a decision at that time as to what change needs to be made. Okay.
Okay. So he currently has him for the week because we're on the summer schedule. Do I just allow him to keep him until it's okay?
Until we make a change, I think we need to continue with what is in effect right now.
Okay.
Right. So I'm setting a further hearing then on July 5th at 9 o'clock on Zoom.
Okay.
And be just like today, and I'll probably take it at the end of the docket so we have plenty of time to discuss what we need to do.
Okay.
All right. So
Thank you.
Thank you. And Ms. Lawrence, it sounds like you were involved before. You don't have any updated information at this point, right?
No.
I'm not sure that I'm going to reappoint you or ask you to step in. I'm just going to hear from the parties on July 5th. Okay.
Sounds great. Thank you very much.
All right. Thank you.
All right, Christopher Olson and Tiffany Johnson.
I'm here.
And is Mr. Olson present?
Yes, I'm here, Your Honor.
I'm trying to be added in on a different computer because my battery's dying. Are you able to do that?
If you had a different computer, you just need to log in on it.
I am. It says the host will let you in soon.
Oh, okay. I will let you in.
Thank you. Thank you.
Okay, so this is on today. I'm looking at a June 21st order. Where the court found adequate cause to hold a full hearing or trial regarding the petition to modify the parenting plan that was filed on March 30th. So I'm not clear on what the motion to show cause on today is about. Looking at the file, I don't see. I see a motion for adequate cause. I see a finding that there was a finding of adequate cause. The matter was sent to mediation and the mediator reported that essentially mediation didn't occur because Mr. Johnson didn't, or Mr. Olson, excuse me, did not attend. So I'm not clear on what the matter is being, what's being addressed today.
So, I started this motion to change the parenting plan due to changes in behavior from Chris. There's been a lot of changes in his parenting and being late picking up. I had approached Chris to see if he could give me a drug test, and he said that he would need a week. And this was before I started the change of parenting plan. He's been reapproached 3 different times, and every time he has said he needed a week. I explained that I would pay for it. I just need to know that he's not using, because he used to be very involved in Zach's extracurricular activities, school, things like that. And he no longer is. He's late picking up. His girlfriend has a open CPS case for drug use, and she is the one that picked Zach up on Sunday. And I'm concerned. Chris is 6.5 months late on child support, which I'm not trying to increase the child support, but he has him for a week on, week off during summer. And if he's not able to pay that $100 during school, I'm concerned about how he's feeding him and supporting him, basically. All I'm asking for is him to have him every other weekend and give a drug test. I can pay for it. If he passes it, I'll pay for it. But I need to know that my son is being cared for properly.
Okay, so the court granted the motion for this to move forward based on the concerns I think you just raised.
Well, and we tried to go to mediation. I got a letter from them the first time because he failed to do it in a timely manner. Then when we scheduled, the mediator called him, tried to get him on the Zoom, and he didn't answer. And then he has also missed 2 court appearances in the meantime.
Okay. So apparently we're on today to address whether changes will happen or not. Let me look at the. All right, Mr. Johnson, or I'm sorry, Mr. Olson. I don't mean to keep calling you Mr. Johnson. I'm sorry about that. Mr. Olson, do you have a response?
Yes, I do, Your Honor. First of all, Kelly Carneal does not have an open CPS case. That is a false accusation right there. That her kids' dad has been, since we have been dating, caused numerous problems in her life. He's done this numerous times, and she does not have an open CPS case. Second,
okay, so I understand that position. Go on to any other response you want to make.
Yeah, well, she says that haven't been involved in Zach's education or his sporting events. They moved to like Vernonia, which actually I don't even know where they live, because, and in fact, in the parenting plan, I'm supposed to pick them up at their house, but they have me pick them up at the stop sign down the road. So I really don't even know where they live. And it's actually been like that his whole life. She tries to keep where they live a secret from me, and treat me like I'm a weirdo or something, that I've never done anything. It's kind of ridiculous. And you know what? As far as sports go, since he was started T-ball, I have always been at least an assistant coach or on the field helper in all of his basketball and his baseball. And now I can't, because I was working and got off at 3:30, and the sporting events, they're we're supposed to get schedules online with the school's website, and I wasn't able to get like accurate ones for the basketball this year, and it's really tough. The drive over there, they live in between Vernonia and Jewel, and it's a long ride. It's like a 40-minute ride, and in wintertime, that road is crazy. I was late. And you know what? I'm sorry, I'm 7 minutes late or 2 minutes late. Then she writes down or texts me about being late. On Sunday, the pickup spot got changed, and I wasn't aware of it until like that day that I was supposed to be in Grand Mound to pick him up at the Grand Mound exit. And yeah, I was like 12 minutes late. And then they are taking pictures of us and accusing Kelly, and there is not an open CPS case. Your Honor, this is like, and she did not ask me 3 times to provide a UA. They did at first, and I refused it. And because I feel it's a control thing, but if they want a clean, I can, and I told her this, that I could provide a UA with them, and she refused it. So that's like her word against my word. And if you want a UA, I will take a UA right now. And I've been unemployed since December, and I have been struggling financially. And believe me, I hate owing child support. It is not where I want to be. But like and my unemployment ran out. I'm struggling to make ends meet right now.
And we're not addressing the child support issue today. So
okay. I'm sorry, Your Honor. I don't know what else to say. I was like diagnosed with diabetes within the last couple of years, and I'm just getting used to being diabetic and getting the proper diet, and not eating the things. And the last couple of months, I've really been dealing with like swollen feet, and I have I backed into a bed frame, and it cut my leg open, and I'm having a hard time getting that to heal. And I'm seeing a wound specialist. I know I'm not sure why you need to know that right now. I'm sorry. The every weekend, it seems to be working out fine. Every other week during the summer, everything seems to be working out fine. If she wants me to UA, I can provide one for her. I just don't want to waste any more time. That's about all I got to say. Oh, I was supposed to get another mediator. The mediator we had was the same mediator that I had with my renter case. So she had a conflict of interest, and I was supposed to get a new mediator, and no one let me know I didn't even know about the second court date. I'm sorry about that. And the mediator I had didn't know. When I asked her about it, she said she wasn't sure, but I was still waiting to be appointed a new mediator, and that never happened.
okay, what I'm going to do in this case, I am going to order that you submit to a hair follicle drug test. And Ms. Fellows, are you still here?
Yes, Your Honor.
Do you know off the top of your head who's doing hair follicle tests locally?
Excuse me, Performance Occupational on Hudson Street.
Could you say that again?
Performance Occupational.
Okay. So I'm going to order you to submit to a hair follicle test at Performance Occupational. That's, I don't know the exact address, but that's on Hudson Street in Longview. I need you to do that no later than Friday of this week. And you'll need to provide the result to the court. And
Would you like the address, Your Honor?
I'm sorry, go ahead.
Would you like the address?
If you have it.
It is 1516 Hudson Street, number 201.
Mr. Olson, did you get that?
15 what? What was that again?
1516 Hudson, number 201.
Okay, I got it. Okay, I got it. Thank you.
Okay. We're going to review this on July 21st at 8:45. If the result of the test is positive, or if you don't take the test, I'm going to treat that as a positive result for controlled substances. And so if you either don't take the test or the test is positive, you'll pay for the test. If the test is negative, that is it doesn't show controlled substances, Ms. Steinweg will pay for the test. And then based on the information coming out of that test, the court will look at what's an appropriate schedule. But I think right now we're going to stick with the every other weekend. Every weekend, the current schedule. And that'll be reviewed again on the 21st at 8:45, July 21st, 8:45 on Zoom.
And will the court docket say just self-represented again?
No, it's going to be presentation docket for myself, Thad Scudder, presentation for Thad Scudder.
Okay.
Any questions from either of you?
Nope, I think that's it.
No, I'm good. Thank you.
All right, that'll be the order of the court.
Thank you.
And I believe that concludes this docket. Thanks for the help with that, Ms. Fellows. I appreciate it.
Very welcome, Your Honor.
I'm
just going to start with number 1 on my docket. This is 14-3005100. This is Tiffany, formerly Johnson. I believe I see you logged on.
Under Steinweg.
Steinweg, thank you. And Christopher Olson. Now, I believe he has scheduled for an iPad booth. Are you in booth number 2, sir? Christopher Olson? No. What is your name?
I'm Brett Havens.
Okay. So I'm gonna need, can we get someone, Christopher Olson's first up, and I think he's waiting for a Zoom booth.
He's standing right here. You want me to step out for him?
Yeah, if you wouldn't mind swapping out with him, sir, that'd be really helpful. I appreciate it.
There you go. She's waiting here.
Hi, yes, I'm Christopher Olson.
Thank you, Mr. Olson, for being present. So as I understand the history here, and I'm going to call you Ms. Steinweg, but it's somewhat confusing because the court, you haven't filed a formal name change on your case, so you're still under Tiffany Johnson. But Ms. Steinweg, you had put this on. There was a previous finding by a judicial officer of adequate cause. The judicial officer had sent you all to mediation. Mr. Johnson, you had failed to appear, or excuse me, Mr. Olson, you had failed to appear for that. So this got put on for trial assignment on a new parenting plan. Ms. Steinweg, as I understand it, when you went to trial assignment, you were not able to get that date assigned because the judicial officer let you know essentially Mr. Olson was in default status since he hasn't filed a response.
Correct.
So you did file this motion for default, which is in accordance with what happened at your trial setting. Since that time, Mr. Olson, you have filed a response to the default. I did receive your declaration affidavit of September 14th, indicating your reasons for non-appearance previously in this case. So
Was that supposed to be served to me as well?
it should be. Mr. Olson, have you served that on Ms. Steinweg?
No, I just to the courts.
Okay.
Kind of been a confusing process for me.
I understand. In moving forward through these processes without an attorney can be confusing. What I'm going to first require today, I'm not entering default today because Mr. Olson has appeared. The law favors judgment on the merits. When someone has appeared despite prior non-appearance, the court generally will not enter default. However, Mr. Olson, essentially that means kind of this is your kind of last attempt to not go into default. So I'm going to set you all a new review date with this court. And by that date, I need you to file a response to Ms. Steinweg's request. But I also want to ask the two of you, do you want to be referred back to mediation?
Your Honor, I'm at the point where he has been requested to do mediation, hair follicle test. He has not done anything that has been requested of him.
Okay.
And now, the weekend before last, my son was in an accident where he was at his house and suffered a serious concussion, and he's not following the doctor's guidelines. It's
Okay. So let's do this then. Has he been served your proposed parenting plan?
yes, back in March, I believe.
I see that March 30th. Okay. Mr. Olson, do you have the proposed parenting plan from Ms. Steinweg from back in March?
Yes.
Okay. I'm going to set a review date. If you all are available next week, I'm just going to give you 1 week because this has been going on since March. I'm going to give you 1 week to file a response to the proposed parenting plan. Otherwise, I will again entertain Ms. Steinweg's motion for default. So you have one. Are you both available October 4th at 9 a.m.?
I am.
Yes.
Okay. So I'm going to give you until October 4th, well, really October 3rd, to file a response on Ms. Steinweg and this court as to your position on the proposed parenting plan. I want to be really clear. If you don't hit that deadline, I will entertain another motion for default, and it would likely be granted at that time. If, however, you do respond, then when we come together next week, I'll get you both set on the trial assignment calendar. Okay?
Okay.
Ms. Steinweg, do you have any questions for me?
What will the docket say? Just self-represented again?
Yeah, it'll be just the same as this morning. It'll say self-rep family law A.
Okay.
Okay?
All right.
Thank you.
Just going to fill out this order quickly. I'm going to just make a note for the clerk's minutes that this is denied without prejudice so that Ms. Steinweg may refile if a force her to do it.
Thank you.
Okay, thank you for having those ready for the court.
Have a great day.
Thanks. Okay, and then I think in our other Zoom booth, we have number 1 on our docket. Christopher Olson. This is 14-3-00-5100. Do I have Tiffany
I'm here.
Steinweg, formerly Johnson? Okay.
Yeah.
Thank you. All right, and Mr. Olson, can you hear the court?
And
Okay. Let me just get into your digital file. So when we were here last, I denied Ms. Steinweg's motion for default because Mr. Olson, you did appear, but I gave you a deadline of today to file your parenting plan response. I haven't seen anything come through.
I'm
Where
sorry.
Go ahead.
I did turn in some paperwork today. Your Honor, I've had the hardest time. It seems an attorney would have been great for me. I mean, even yesterday, I came in yesterday to turn in my paperwork early. I had to attach some attachments, and when I went to go get them printed, the Wi-Fi wouldn't work and I couldn't get them printed. And it's like one thing after another has with the case.
Did you, so just to check in, did you file your response to the parenting plan today?
Yes, this morning. I was here first thing this morning.
Okay. Sometimes, and you would not have any reason to know this, but sometimes people will provide what's called a bench copy. So, because it's going to take about 4 days for me to wait for it to be digitally scanned in. So I don't have any way to see what you have filed. So what people will do is provide the clerk with a hard copy saying, give this to the judge. That way I have it in front of me for today's hearing.
Yeah.
I assume you didn't do that.
No. You know, I apologize. And it just seems like that I should have had a copy for Tiffany to have, you know,
Well, so that's my next question is you do have to serve Ms. Steinweg with whatever you're filing with the court.
Okay.
I will give you some additional time to get that done, but I know I don't want to keep taking up Ms. Steinweg's time for your failure to get these things done on time.
I am so sorry.
Okay. When can you get her copies of the documents you have filed with the court?
Today, I mean, absolutely, I can today. Now they live quite a ways away. I could email them to her, I guess. I could do that, yeah, or text them to her.
Well, let me ask Ms. Steinweg, because we presume personal service, but Ms. Steinweg, would you be willing to accept email copies of these documents for purposes of moving this case forward?
Your Honor, at this point, last week he was given a date and told that if he didn't follow through, that we would consider default.
Correct.
And at this point,
that's not my question. He has filed his answer with the court. My order says he has to file it by October 4th. He did that. I'm not saying that he's done a great job, but I'm saying he met the bare minimum for avoiding a default. And I
will accept them however I can get them.
Okay. What is it? Does he have your current email?
I don't. It's the paperwork, but
I can just text it to you if you.
I'll send you my email address.
Okay, that would be great. So Mr. Olson, if Ms. Steinweg's available next week, I'm gonna set this over 1 week. That'll give me time to review your response. You'll have made service on her, but then we really are moving forward because I absolutely understand Ms. Steinweg's frustration with what is happening here. We can't.
I understand.
We've done the bare minimum to avoid default, but that's not saying too much, okay?
So, I mean, really, we could probably resolve it right now. Like, I could tell her, you know, what I have done, you know, and what I'm doing now. And I know that she was really concerned because the judge wanted me to take a hair follicle, and I have been going into debt. Like, I lost my job in December, and unemployment ran out, and I had to have emergency surgery on my leg, and I can't work, and like I'm struggling so bad financially, that another $350 for a hair follicle. And Your Honor, I will admit to that after 14 years, I relapsed. After I lost my job, I got into a funk, and I relapsed. And when they admitted me for my emergency surgery in Portland on my Achilles, that was it. That was July 22nd. That's the last time I got myself into outpatient treatment. I'm still in.
So back on August 1st, you were ordered to submit to a hair follicle test, or excuse me, back in July, you were ordered to submit to hair follicle testing. And then by August 1st, a judge issued a ruling that you had failed to appear at the July 21st hearing, that you had not provided results of the drug test. So the court presumptively found that those results would have been positive. Have you done a hair follicle test since August 1st?
No, I have inquired on one. Like I said, it's $350. And really, I didn't know they need an address to send it to. And I don't know where I would put down for them to send the results to. I will go get one today. It's not as easy as it sounds. But like I said, I'm going to end up paying for it, and I really can't afford another $350, but I would absolutely go do that if that's what you're.
So, well, I mean, it's not what I ruled, it's what another judicial officer in this county has already ruled. I'm not going to overturn that. That's still an outstanding obligation of yours.
Okay.
But let me just ask you this for purposes of moving this along, so we know what we're doing next week. Are you objecting to the Ms. Steinweg's petition to modify the parenting plan?
Yes.
Okay.
Well, she wants me to only get him every other weekend. I'm not going to do that. That's not enough.
Okay. Okay. Well, I will review that objection when it is I'm assuming that's what you have filed with the court, is your statement regarding your objection to her request. Is that correct?
Yeah, I wish.
I will review that. We will hold a hearing on that issue next Wednesday at 9 a.m. I would tell you that, again, I'm going to reiterate that your obligation to get hair follicle testing is still an outstanding obligation. Failure to do so leaves the court with no option but to consider that your failure to do it means the test would have likely been positive. So,
well, I'm admitting that I relapsed. I mean, why? I mean, you just want it on paper, and then for me to go $350 more into debt that I don't have doesn't make sense to me, but that's okay. I'll do it.
okay. Ms. Steinweg, are you available next Wednesday? And again, I understand your objection to another set over, and I understand your frustration with this process, but we will move forward next Wednesday.
I am.
Okay.
I apologize.
We will see you both back 9 a.m. Next Wednesday, which is, what's the date?
11th.
The 11th. Thank you. To get my calendar out here. Okay, we'll see you back next week. Thank you both.
Thank you.
Then we have Mr. Olson. I believe that's you in iPad booth 2.
Yes.
Okay. And then Tiffany Steinweg. I almost said Johnson, and then I saw the name on the Zoom screen. Okay. So we have been here a few times on a motion in order for default. I know Ms. Steinweg has been taking great efforts to get a change to the parenting plan done. Adequate cause was granted previously. the next step was for Ms. Steinweg to have a hearing on her proposed parenting plan, given that a judicial officer did find adequate cause to modify or at least re-review the parenting plan. What happened from there appears to be that mediation was scheduled instead of a hearing. Mr. Olson did not show up for that mediation. A judge, hold on a second, I'm not done yet. A motion to show cause was set, but then converted to a trial assignment. When Ms. Steinweg went to get a trial date, the judge told her that it appeared Mr. Olson was in default status, and so they couldn't continue with the trial. And I'm just reciting this so that Ms. Steinweg knows I am very aware of all the steps she's taken to try and get where she needs to go. Mr. Olson, you recently, once the motion for default was brought, did appear. The court gave you a deadline initially to respond. You failed to respond by that date, but indicated some reasons for why and that you were going to get that done. I do see, so our last hearing was October 4th. I had set that date as the deadline for you to file a response to the modification to the parenting plan. When we were here, it was not in front of me because you had just filed it. It has been filed with the date of October 4th. So I know that you have filed a response on the deadline I set for you. My question is, did you serve that declaration on Ms. Steinweg? Has she had a chance to see what you sent the court?
Yes.
Okay.
Your
Ms.
Honor.
Steinweg, yeah, go ahead, Ms. Steinweg.
So he was supposed to email me it, and that never happened. So Sunday, I asked if I could pick up a copy. I did get a copy of 2 pieces of paper that were typed. However, when he texted me a picture of 2 different pieces of paper. So he said that he's confused and unsure what he actually turned in. So I don't know if what's in front of me is what he turned in or not.
Okay, let's see. So the document that you have, I'll just kind of read to you the first sentence I have, what he filed, and tell me if it's the same thing you have. So the document I have is, let's see, 1, 2, 3, 4, 5 paragraphs long. And it starts with, to begin with, I would like to thank the court for this opportunity to write this declaration.
Yeah, that's correct.
Okay, and then the very last sentence is, once again, I would like to let the court know my appreciation in this opportunity to submit this document.
Yes.
Okay.
That's what I have in front of me.
Okay. Okay. So Mr. Olson, go ahead, and then we're kind of going to work through what our next steps are here. Go ahead, sir.
About the mediator, when we were supposed to get with the mediator, the mediator was working with me on my rental, my rent. Since I had lost my job, we had a contract going with my my renters, and that mediator had to back out, and they were supposed to give us another mediator, and I don't know if Tiffany even knew this. So I did miss that one court date, thinking that we had to see the mediator before we went to court, and that wasn't the case. And so I wish I would have seen the mediator, not just for the help for both of us, but obviously for me, because I really have just like not knowing what I've been doing through this whole case. And I am sorry for wasting everybody's time. Every time I come to court, it seems like I've done something wrong again. Like I went from low self-esteem to no self-esteem. So I'm just as frustrated as Zach's mom in this matter. I just would like to move on.
Have you done the other things the court ordered, like the hair follicle test or UAs?
Okay. I have,
and I know, and hold on, sir, just a second, because I know, let me just say this comes from a place of, I don't want to hear excuses. I just want you to tell me, because you've told me your excuses before and why you don't think that you need to do it. So I really just need you to answer the question right now, which is, have you done the drug testing that the court previously ordered?
No. And
Okay.
would you why?
I've heard your reasons before. Last time, I assume it's the same. Last time you told me it doesn't matter because you're admitting that you were using and that you had relapsed. So yes, it would have been positive. Is that essentially?
Well, no, I've tried to get one, but you have to have, it's $350. And I've talked to the secretaries here on information. They need a GAL or a attorney to an address to send it to. I even went to the legal advice place to talk to them about how I could get the hair follicle paid for and up front, but they need the money up front. I can't just go get a hair follicle taken.
So you don't have the money to pay for the hair follicle testing?
No, Your Honor, I am so financially hurting right now that I'm struggling to keep my apartment right now.
Ms. Steinweg, do you want to say anything to that?
It's just interesting to me that he has boats and all these things outside of his home, kayaks and things like that. And honestly, if you wanted to put your child first, you would get rid of those things to do this. I mean, I just don't feel like it's his priority right now.
Well, and at this point, you know, the court order is essentially, you know, visitation is contingent on you getting those things done. So I do think that should be very high priority for you, sir. Ms. Steinweg, what I'm going to ask you, did you have to pay for the mediation that he didn't show up for?
I paid the first time I paid, and then they sent me a letter saying that he didn't do it in time. The second time I paid, and he was able to, they called him on that day to try to get a hold of him to see why he didn't want to do it. He didn't answer the phone. They gave him 20 additional minutes. I did pay again. However, they reimbursed me my money.
They did reimburse you
Yeah.
was that for the June mediation that he didn't show up for? They reimbursed you for that?
There was that one, and then there was one before that we were supposed to do, and he didn't follow through with that either.
Okay. Well, let me ask you this. He is here now. He's responding. I think the prior judicial officer, why he sent you to mediation is he said it would be cheaper than getting a GAL involved, which is true. So I guess the question for you, Ms. Steinweg, that I would have is to proceed forward with getting your parenting plan changed. We can do a couple things, and I'm going to leave it in your court to tell me how you want to proceed because it's your motion. We could certainly get you back on a trial assignment docket to actually have a, you know, 1 to 2 hour hearing on the parenting plan that you're proposing. Now that he has responded, he wouldn't be considered in default. So we could get that set for you. You probably would want a GAL to testify in that type of situation. Or we could do a final mediation set. And I think at this point, I'd put the cost of that on Mr. Olson. So do you want to give mediation one more shot before we move forward with trial, or what is your request today?
I just don't feel that we're going to come to an agreement at mediation.
Okay.
And if he already hasn't followed through 2 times, I just don't understand why we're giving him so many opportunities. I mean,
well, we're giving him opportunities because he's not considered in default by appearing after you filed your motion for default. He did appear. He has now filed a response. The law favors a resolution on the merits, not a default. So that's why. Those are all of the reasons that if I were to enter a default and just give you what you want today, it would get reversed on an appeal. So that's why we're doing the things now so that this doesn't drag on for 6 more months. So
okay.
If you're saying you don't want to do mediation, I am fine. I understand your reasoning. I understand you all have tried this twice before. I understand that it is unlikely, especially with Mr. Olson not adhering to court orders. I can understand your position for thinking it wouldn't get you anywhere. So we could get you set for a contested hearing on the underlying parenting plan. I do believe you would want me to appoint a GAL that meets with the two of you and makes a recommendation to the court one way or the other about what the parenting plan should look like. If I do that, I'm going to inquire about each of your finances to determine if it's going to be at county pay or private pay.
Is he able to pay for a mediator? I mean, I can pay my own portion. That's not the problem. The problem is trying to come to an agreement.
Right. And I understand. I hear you loud and clear. Yeah.
And I don't understand why he's even fighting this, considering I'm already getting him at least one additional weekend a month to get him to his activities and things like that. I just don't understand why.
And I can't answer that for you. All I can say is I understand your frustrations, and what I can do is ask you which venue you would like this to move forward with. We can move you on to a contested hearing.
Let's do the mediator and try to do that one more time. And then I guess we'll just move on from there.
Okay.
So is there a specific mediator that we cannot use? There shouldn't be a conflict of interest as they're just trying to resolve issues, correct?
Yeah, well, and that's news to me. I don't see anywhere in the documents that a mediator has said they had to recuse because of a conflict. The June mediator just simply said Mr. Olson did not show up. So that's at the Community Mediation Center in Longview.
And there's multiple when you go on the video chat.
I would be sending you back to mediation at that same place. Mr. Olson, let me ask you, are you open to mediation? Will you meaningfully participate in mediation?
Yes.
Okay. I'm going to do two things. I will send you all back to mediation. I'm going to have the orders in here. Okay. I don't know where they are. Oh, there we go. I know where they are in Portland 1. All right. Mr. Olson, are you able to pay half of the mediation cost?
Well, the last time I got a discounted fee for being unemployed. And I was able to pay that, and I did pay that. And I also got refunded that too.
Okay.
But yes, I am.
Okay. So I'll go ahead and put the 50-50, and then sir, if you need to work with them on a request for a reduced rate, please do so. Let me make sure I have has either of your addresses or phone numbers changed since the last time you went through mediation?
Mine does not.
Okay. So Mr. Olson, still Voice Drive in Kelso?
Mm-hmm.
And Ms. Steinweg, Nehalem Highway?
Yes.
Okay.
His phone number has changed, or he sent me a different phone number, so.
Yeah, I was about to say, Mr. Olson, I don't even have a phone number for you right now. What is your phone number?
Well, I still am using the 2 number. I just can't call out on that number.
Can you do you receive calls on that number? Okay, go ahead and give me that full phone number.
Well, if you bear with me for 1 second, I don't know my new phone number yet. So bear with me while I look it up for you.
That's fine. And then Ms. Steinweg, while he's doing that, what I'm also going to do is set what's called a show cause hearing on your parenting plan request just back in front of me on a docket, so that if mediation is not successful, we will move forward on that date without you having to go to a separate trial assignment docket.
So if we do not come to an agreement at the show cause hearing, will anything happen, or we'll schedule a new trial date?
What'll happen is if you all go to mediation, If that is not successful, then it's going to come back to me. We'll have a show cause hearing on your request to change the parenting plan in front of me on this docket. So
Okay.
you're not going to be asked to, you do not think last time that's how it was going to go, but then you, and again, through no fault of your own, it's difficult when you're not represented. You did file a trial assignment request. I'm not going to have you do that this time. I'm going to keep the show cause hearing for your underlying request to change the parenting plan on this docket. So we'll set a date for that today.
Okay.
Once again, Tiffany has the phone number on her phone for this new phone number. I'm not sure how to get in there and find out the phone number of this phone.
Are you ready?
I am, yes.
Thank you.
Okay, I've got that on the order. On the last page, it asks if you are in agreement with the order I am signing, transferring this case back to mediation. Mr. Olson, for you, are you in agreement?
Yeah, well, I missed what you guys were talking about.
Okay, I'll come back to it. Just hold on. I'm asking, are you in agreement that I signed this order sending your case back to mediation?
Yes.
Okay, and then Ms. Steinweg, are you in agreement?
Yes.
So I'm going to indicate your agreement via Zoom. Mr. Olson, you had a question for me. Go ahead.
Yeah, on getting a hold of the mediator and how am I, what will they be getting a hold of me? Am I supposed to get a hold of them? Do you have a phone number I need to get? Because I know it doesn't look like I've participated and whatnot, but believe me, I don't know. What do we need to do to get a hold of the mediator? What do I need?
So I can send all that information to him.
Yeah. So I guess, Mr. Olson, I'm a little confused because you told me you've been in touch with them before and you've used them before. So, yeah,
well, you guys don't have any recollection of them saying that I needed to get a different mediator, that that there was a conflict of interest. And now I don't know what to say to that. Like, why, how come nobody knew about?
So let me just ask you a question, Mr. Olson.
Yes.
Does that have any bearing, that issue that you're raising right now that you seem so upset about, does that have any bearing on whether this court should change your parenting plan?
Well, no, but it's
okay. So we're going to move on. So what I'm telling you is you are being referred back to the Community Mediation Center. The phone number they will receive a copy of this order. The order has both of your phone numbers on it. They will reach out to you. You are free to reach out to them if you would like. Okay. The last thing we're going to do is set a show cause hearing date if mediation is not successful. This is the date by which both of you will be asked to present your evidence as to why a parenting plan should be changed or should not be changed. Let's see. I don't know how, do you all recall about how far out they were booking the last time you did this?
It was about 2 weeks, I think.
Yeah,
they were pretty quick, actually.
I was going to say 2 or 3 weeks. So let's set you out just 30 days to November 8. If you're both available, November 8 at 9 a.m.
Yep.
That'll be our show cause date for the change to the parenting plan. Essentially, Mr. Olson, a contested hearing where you would be bringing forth testimony and evidence as to why you don't think the parenting plan should change, or if it should change, what changes you're proposing. If mediation is successful, we will strike the November 8th date, or at least we'll strike the November 8th show cause. We'll keep the date to review the mediation results though.
Okay.
Okay. Any questions for me?
Nope.
Mr. Olson, any questions for me?
Yeah, on the hair follicle, where do we stand on that now?
What do you mean, where do we stand on that? You and I have talked about it every time you've been here. And I've told you there's a standing order from a different judicial officer that I am not changing. So it remains an obligation of yours to complete. And I would say this, the allegations of drug use were a significant part of the reason that the judicial officer found there was adequate cause to review the parenting plan. So yes, that still is a standing order.
Okay, because I was down there yesterday, trying to get one, and I don't have $350. I also need an address for them to send it to. If I have a miracle, and someone, or I get help paying for it, I need to give them an address to send it to.
They routinely file those with the court.
Okay. Oh, what place are you talking about? And who are they? Because the place that I went to, they don't know.
I'm not sure what you're asking me, sir.
But when the court sends somebody to get a hair follicle, where do they send them? Because the secretaries out here on the second floor, they don't know.
I believe
The judge told you where to
yeah,
go.
I was going to say, I'm just looking at the notes from the hearing. I'm just going to go back there. I think the judge specifically addressed it. Yes, you asked this question, sir, on July 5th of 2023. Okay. So you were in front of the court, and I'll give you the exact time. You were in front of the court at 10:25 a.m. on July 5th, 2023, in front of an elected Superior Court judge in this county, Judge Scudder. And you asked at 10:31 a.m. where you needed to go. And at 10:38 a.m., the court responded, Mr. Olson to obtain hair follicle test at Performance Occupational in Longview no later than Friday of this week and provide result to court.
Okay, their address changed. Perfect. That's the place I went to.
Okay. Any other questions for me?
No, Your Honor.
Okay. Ms. Steinweg, any other questions?
No, thank you.
Okay, thank you both. You're free to log out. And then have I missed any cases on our docket? Okay, we'll go ahead and log out and end docket.
100, Christopher Olson and Tiffany Steinweg. Do we have Mr. Olson with us today?
I don't see that he's here.
I don't see that he's here. Ms. Steinweg, what I noticed from our last hearing was that we sent you all back to mediation. Has that mediation occurred?
No.
Okay.
So I paid the day after, which was October 12th.
Okay.
Leah works at the mediation office. She had reached out to him on the 17th. I emailed her asking if we could schedule. She said he hadn't paid. The 19th, he texted me saying he was taking his hair follicle test, which I haven't seen any results for that, but the 20th, she asked me if he pays, what will work. He finally paid on the 30th, I think.
Okay.
But as we went over in court last time, it takes 2 weeks for them to schedule. So the soonest she could get us in was the 14th, but I haven't heard anything else.
The 14th of this month?
Yeah.
Okay. Well, so did you all actually schedule for the 14th?
I scheduled just because I'm
Okay.
honestly feel like I'm beating my head against a brick wall.
Yeah, I can understand that. Here's what I'm inclined to do. If you have the mediation, and I know Mr. Olson's not here, I will make note of that in our minutes. Let's just set you out 1 week to the 15th. So you'll be back and Mr. Olson will need to appear And if he doesn't, we'll move forward without him because he's had notice of the show cause that has been filed. And I'll note for the record, when he was here at our last hearing, I was very clear that if mediation was unsuccessful, we'd be moving forward on the show cause motion today. And he is not here. The only reason I am not going to move forward today is because I want to see if mediation occurs on the 14th, if he shows up, and if mediation is successful, win-win for everyone. But if he doesn't show up on the 14th, or if mediation is unsuccessful, then the following day, Wednesday, November 15th, we will move forward on your show cause motion.
Okay.
Does that work okay for you?
Yeah.
Okay.
Yeah.
All right.
It's just upsetting because, I mean, this is the third time that we've tried to do this. So.
Understood 100%.
So November 15th at 9.
November 15th at 9, go ahead and log back on. And if for some reason mediation is successful, great. But I am guessing I will see you on the 15th and we'll move forward on your show cause.
I'm sure that you will.
Okay, we'll see you.
Thank you.
Yep.
Thank you. Okay, I'm going to move to number 3 on my docket, 14300510. This is with you, sir, Christopher Olson in iPad booth 2. And then I did see Tiffany. There you are, Ms. Steinweg. Thank you. So, Mr. Olson, are you able to unmute?
There you go. Sorry.
Okay. So, Mr. Olson, we missed you at the last appearance. What happened?
You know, it figures. Well, we are seeing the mediator. I thought we were supposed to see the mediator before we had court. I apologize.
Did you all end up going to mediation?
Yes.
Okay.
We still have one more session to do. And also I was just informed that my hair follicle results are back. So
yes, they are, and I have reviewed them.
Okay, cool.
Yep. We'll talk about that in just a minute. Ms. Steinweg, what update do you want to give the court regarding mediation?
I feel like a little bit of progress was made in communication. However, I don't feel like we will come to an agreement as he's not willing to give up any time or make any changes to the parenting plan.
Okay. When's your next mediation scheduled?
Tuesday, I believe.
Okay, Tuesday, November 21st. Okay. Are you, Ms. Steinweg, planning to attend that mediation?
If we don't make any changes today, yes.
Okay. Well, here's what I want to say. And Mr. Olson, you have to understand, especially with your lack of appearance, this has been a long process for Ms. Steinweg to show up and have you not be here and then show up. I am going to request that you both attend the mediation on November 21st. But I'm going to give you, Mr. Olson, some pretty specific kind of guidelines that I would like you to consider as you go through that mediation. I understand that currently you are not wanting to budge at all on the parenting plan. But I am looking at your hair follicle testing, and I am telling you that it does not look good for you. Okay. What that means is you have a choice here to work with Ms. Steinweg in mediation and give a little, or you both are going to end up back on my next docket on a contested parenting plan. And based on this hair follicle testing from October 19, 2023, there are several positives of different substances. So I would be, in all candor to you, Mr. Olson, and I hope this gives you a reason to really work in mediation on giving a little, the things that you are popping as positive for are types of substances that absolutely give me concern for the safety of a child being with you. So please take that information and give mediation on Tuesday, the 21st, your all. Because I am telling you, what I am seeing is troubling for the safety of your child. Okay?
Okay.
So you may need to give a little more than you might otherwise want to. And that's the purpose of mediation, is to come to a compromise with Ms. Steinweg. But again, if you can't come to that compromise, I'm happy to look at the facts that are now in front of me and make that determination myself. Okay. But there will be limitations. If I was making this decision today, there would absolutely be limitations on your parenting given the significant positives on this hair follicle test and the types of substances it's positive for.
Okay.
Okay. So you all mentioned the mediation is on the 21st. Is our 29th docket open? Or even 22nd, I guess, but I know that's kind of pushing it.
The 22nd is open, the 29th is open, they're both pretty low.
They're both pretty low? Yeah. Oh, okay. So Ms. Steinweg, I'll give you kind of first choice since I know you've been here multiple times. I could squeeze you in next Wednesday, the 22nd.
I would prefer to do it as soon as possible.
Okay. Mr. Olson, would you be available next Wednesday, the 22nd at 9 a.m.?
Yes.
Okay. So I am going to move you over to that date. And like I said before, you know, it is in your best interest to really, truly, in mediation, let them mediate, let them help you come to a compromise. But if you don't, the very next day, I will make a decision on those things based on the evidence I have in front of me. Okay?
Okay.
All right. Any questions for me today?
I have a question.
Yes.
So with the information that you have, am I able to keep Zach until we go back to court next week so that we can make some changes then? Or
Yeah, is there currently visitation happening with Mr. Olson?
oh yeah, he gets him every weekend unsupervised.
Okay. So Mr. Olson, I am going to cancel. I'm going to do Mr. Olson.
Yes, Your Honor.
Okay. I am Mr. Olson, hold on. I am issuing a bench order that suspends visitation this weekend until our next court date because of my significant concerns over child safety, given your positive hair follicle testing for substances that I would call potentially fatal if a child came anywhere in contact with them. So I am going to be issuing that bench order, and I'm making an oral ruling here from the bench that there is to be no visitation until we come back on the 22nd. There can be phone, I will allow phone visitation,
okay,
but there is to be no in-person visitation.
Okay.
Okay. All right. Thank you both. We'll see you back Wednesday. Please give mediation your all.
At 9 o'clock.
9 o'clock. Yes.
Okay. Thank you.
Thank you. Okay. Let's go to number 4 on the docket. This is Jordan Conover. Number 1 on our docket, 14-3005100. I see Christopher Olson present, and I believe Tiffany is.
I'm here.
Steinweg is there. Thank you. What I was looking for was an update on the mediation that was supposed to take place yesterday. What can the parties tell me?
What happened yesterday was we came to an agreement, not on a permanent basis, but temporary until December 31.
Okay.
And that would be, he would get him every other weekend, but his mom would supervise.
Okay. Did you all want that to be a part of a temporary parenting plan, or are you both just asking for a bench order on that agreement through December 31st?
My concern is that the mediator said that if we do this and we don't come to court or have a final parenting plan in place, then it's going to go back to the original order, and I don't want to go there.
Okay, so I could give you two options. One, if the only thing needing to get done right now through December 31st is a change in that visitation to supervised visitation and specifics regarding when that occurs, I can do that in a bench order for you today, and then we could set up a follow-up review date to work on final orders. Or if you want to present me with a temporary parenting plan that you both sign and agree to, I could put you back on a docket next week or in 2 weeks, and I can sign off on that order. I don't know if you worked on a temporary order in mediation. I just don't have the document.
It was just verbal, and then she said ultimately you would make your decision today.
Okay. So, well, what I'm going to do today then is first, Ms. Steinweg, tell me the language that you two have agreed to. I'll ask Mr. Olson if he's in agreement to that. We'll put that in a bench order, and then we can certainly set another date. But I don't create the orders. You all create the orders and present them to me for review. So if you're wanting an actual final parenting plan, either we set that for trial, or if it's an agreed order, you all prepare that and present it to me.
Okay, so what about the show cause hearing that we discussed before? What is that?
We can get to that in a minute. Can you give me
Okay.
the language that you both have agreed to? And
yes.
then Mr. Olson, I'll come to you.
So it would be every other weekend, Friday to Sunday from 6 p.m. to 6 p.m.
Friday to Sunday, okay.
And that would be a supervised visit at Chris's mom's house, which is Kay Gunter. I don't know if you need her name.
Yeah, can you spell her name for me?
K-A-Y.
Okay.
And last name is G-U-N-T-E-R.
Okay, so it's at her home.
Yes.
And she must be present the entire time.
Her or her husband.
Okay. And is Mr. Olson to be present the entire time?
No.
Okay, so he can come and go from that home during visitation. Okay. Okay, anything else that was agreed to?
The other thing was for winter break, we split the break. So Kay would keep him from December 25th at noon till January 1 at 6 p.m.
6 p.m. And again, that would be with Kay.
Yes.
Okay. And that'll just be winter break for 2023.
Yeah.
Okay. Okay, so is there anything else?
No, just that he's not able to leave with him. It needs to be supervised.
All right, Mr. Olson, thank you for being here. Is that your agreement and understanding at this time regarding temporary visitation? Oh, you're muted, sir.
Sorry about that.
It's okay.
No, absolutely not. I don't know why I need to be supervised visits. I know that you did get the hair follicle back, and it went back to, well, I got clean on July 22nd. And that's when I got into treatment, and I've been ever since. And I provided with all my treatment, UAs that I've taken at treatment. I've provided like what I have done up to this point, but like nobody's, I feel like, acknowledging that I took care of getting clean months ago. So I don't know. No, I absolutely do not agree to that. And every other weekend. So we're still back at ground zero, except for I've done quite a bit of stuff to better my life and my family's life, with the outpatient and with mental health, and I'm feeling pretty good, except for all this. So what now?
Can I
Okay.
say something?
Go ahead, and then I'm gonna make my ruling.
Okay, so yesterday we agreed to all this through the mediator. Is that not?
You guys,
Mr. Olson, no, thank you. This is her turn. I will come back to you. Go ahead, Ms.
He
Steinway.
even sent me an email, I didn't print it out, but stating that he was in agreement to that. So I don't understand. I don't. Let's just move forward.
Yep. Mr. Olson, what did you want to say?
Nothing. You've already, go ahead and make your ruling.
Okay.
I don't know what to say. I did you not get like the paperwork I turned in or anything? Like
what paperwork?
Well, I dropped off from my
API Community Observer, please mute. We're hearing you in the middle of another case. Go ahead, Mr. Olson. I apologize.
I turned in to the courts yesterday after the mediation from my treatment facility, a letter from the head lady over there with a copy of all my UAs, and she explained that the Suboxone and the methadone that's on there, are prescribed. And then they switched them though, because one of them was giving me stomach problems. And so when you look at my UA, it says positive, but it's positive for my prescribed medication. And also I got a letter from my counselor from mental health.
Okay, so if you turned those things in yesterday, as you've been in this court enough to know, it wouldn't be available for my review today. It takes several days for it to get scanned into the system. You would have to leave a hard copy, bench copy, if you want me to see it 24 hours of filing. So I don't have that. What I do have today is a hair follicle test that is positive for things other than what would be prescribed medication. I assume that you have seen that as well, sir.
Yes.
Okay.
Do you know when that is from?
I have the date in front of me, date collected October 19, 2023.
And so that goes back to when I was using. But like I said, up until July is when I got clean. So I guess the hair follicle, I'm told, can go way back if the more money you spend on it.
Okay.
So I don't know.
Okay. Here's going to be my ruling today. With this recent October 19th, 2023 hair follicle testing, given the comments of the parties, I have no notes for mediation, but I think that the proposed language from Ms. Johnson is more than beneficial to you, Mr. Olson. Based on the hair follicle testing, I had revoked visitation until we got more documentation and information in. I think that the proposal from Ms. Johnson is very appropriate under the circumstances. I am going to issue that temporary bench order. I will get that issued today. It will specifically state that during visitation, your mother, Kay, is to be present at all times. You are not to take the child out of her home unless she is with you. So she or her husband need to be present for supervised visitation. I will set a review date so that we can review the documents you filed yesterday The other outstanding issue was that Ms. Steinweg had filed a motion and order for default. I had initially denied that because Mr. Johnson, or excuse me, Mr. Olson, you did appear. You did provide a declaration affidavit regarding your position regarding a final parenting plan. In this case, the problem I have is you haven't really filed a formal response, but I am going to find that it's enough to avoid a default order and move this case on to the merits. So I am going to deny the default. I am going to issue that bench order. Ms. Steinweg, what else are you asking for the court today before we set a review date? And I'll just let you know at this point then, since it sounds like mediation was not successful, your options would be to get onto our trial assignment docket and get this case scheduled for either a mandatory settlement conference or a trial.
I would definitely like to do the mandatory settlement conference. Because they scheduled us for another mediation, but if it's pointless if we're going to go in, agree, and then come back and it's going to be totally different the next day.
I would agree with that. So let's get you all, I'm going to issue this bench order. Let's set you for a trial assignment docket, which we have those every Wednesday at 1 o'clock. At that time, you will be scheduled in front of a judge that is not me for a mandatory settlement conference. Probably, if I had a guess, it would be early next year, 2024. I doubt you'll have any December dates.
So, but this order will be current until we go to that, correct?
Yeah, and what I'm going to do is set a review date before December 31st on this docket with me, so that we can review how that new visitation is going.
Okay.
So what is the first, would you all be available? Well, is trial assignment open next Wednesday? Yes. Okay. Would you all be available next Wednesday at 1 o'clock to log on for trial assignment docket to get a mandatory settlement conference date?
Yes, I am.
Mr. Olson, are you available?
Yes.
Okay, so November 29, 2023 at 1 o'clock. We'll get you scheduled for a mandatory settlement conference. Then let's get you a new date. Let's get you as close to the 31st. We could do December 27 at 9 a.m. back on this docket to review the visitation schedule. If for some reason you issues come up from either party, you are free to renote it back on this docket for review if you need to. But it would need 21 days notice to the other party. So December 27th is probably pretty close to where you'd end up anyway.
Okay.
Okay. Okay, I will get the bench order issued. Anything else from the parties today?
No, thank you.
Okay, Mr. Olson, any questions for the court?
Nope.
All right, thank you, sir. You're both free to log out. Just going to get into that file. And I just want to say on the record, so Mr. Olson, you probably recognize me.
Yes.
As the judicial officer on a different matter.
Yes.
Do you have any objection to me presiding over this matter? It is wholly unrelated, but I do understand that you know me from a different matter.
I don't have any problems with that.
Okay. And I'll just put on the record that I don't have any independent knowledge of this case. I just know Mr. Olson as the presiding officer in a different matter involving him, but there's no crossover. I don't feel like it will cause any conflict or bias on my part. Mr. McCreary, do you have any concerns?
None based on what's been stated.
It's a family law matter. So, okay. If something comes up, obviously, please let me know. But at this point, we will proceed. Mr. Olson, this is your first appearance. Thank you for being here. Have you reached out to be screened for whether you qualify for low or no cost legal counsel for this matter?
I am working with CAP, and we did get some good news yesterday that they're it sounds totally positive that there's a good light at the end of the tunnel. I've been going through a lot of paperwork and other matters in my life and waiting for disability and Social Security. And I got in touch with my landlords, and hopefully we can maybe set this over, I think is what they want to do also.
Well,
So
let me go to Mr. McCreary. Have there been discussions with Mr. Olson?
I have not spoken with him. My client perhaps has, and my understanding is that CAP has some money at this point. I don't know if that's another treasury thing, but if there, my perception is that if there is money on the horizon or as a potential, you know, that's something that is going to be reached towards. I expect a couple weeks will be the answer.
Okay.
But you know, at the same time, I look at these situations and there's $3,000 and $3,600 in rent owing, and there'll be more rent starting in January. I would hope that if nothing is done when we come back in 2 weeks, that we would be moving towards an order.
Okay. So Mr. Olson, what I'm going to do is continue your case to Friday, January 5th at 9 a.m. In that interim period, you are free to reach out to Mr. McCreary if you have specifics about payment. But also you do have the right to be screened for an attorney at low or no cost to you if you would qualify. On the summons, there is the phone number to be screened for the eviction line. Do you still have that document?
I'm sure I do.
Okay. Do you want me to give you that number today, or are you pretty sure you have it?
You know what, if you have it available, that would be okay.
Okay. And then just so I make sure, Mr. Kiernan, is it the 88 number that you prefer?
I believe it's the 855 number, but let me double check that because I also don't want to give you, yeah, the 855 number is the better one.
Perfect. Okay. So Mr. Olson, it is 855-657-8387. And that is also on page 1 of your eviction summons from Mr. McCreary's office.
Okay.
Okay.
All right.
So the sooner unless you have the money and you're handing it over, the sooner you reach out to that number to start the screening process, the better off you will be, because it is unlikely we'll do another continuance after January 5th. Okay.
Okay. I thank you, Your Honor.
Okay. Yep. You are welcome. All right.
Thank you, Your Honor.
Okay. Let me go up to number 1 on the docket, 14-300-5100. Do I have Christopher Olson and Tiffany Johnson, Steinweg, excuse me.
I'm here.
Okay. Do we have Mr. Olson today?
I have a cold, so bear with me.
Oh, it is going around. That is for sure.
I don't see that he's here.
Yeah, I don't see him either. Okay, let me get caught up here. We set this on today for a review hearing when we were all last together. You all do right now have a non-jury trial set for January 29th, 2024, pretrial management January 10th. January 23rd is your readiness hearing. Mm-hmm. Then I have the last thing I have is the certificate of mediation saying the parties came to a verbal agreement regarding a temporary parenting plan and have agreed to return for a third mediation session on December 22nd at 11 a.m. And was there any update from that, Ms. Steinweg?
So what happened was when we came to the agreement, the next day we came to court. Mm-hmm. And then he said that he didn't come to the agreement. So then you decided on our current temporary orders. And then we agreed that we wouldn't go back because it was basically a waste of time because we sat there
Okay.
for 2 hours, he agrees, and then changes his mind.
Okay. And I recall him saying that, and I just wanted to make sure that you guys had not had a mediation session where you agreed to something after. I remember when he came here and said that you guys didn't agree, even though the mediator said you did. So it sounds like what we need to do is just keep you scheduled for your pretrial readiness and non-jury trial. If he fails to show for any of those, then you can ask the court for any relief you're requesting.
Okay.
Do you have those dates still for pretrial and readiness and non-jury trial?
Yes. And then am I able to get a copy of the hair follicle results? They were supposed to be sent to me by him or the company. Am I able to come in there to pick them up?
Let me double check since I don't handle that side of things. Let me ask the clerk where something is filed under seal.
Either one, just the parties.
Just the parties can. Okay.
With
So
ID.
with ID. Okay. So since it is considered a healthcare record and it's sealed, technically it means it's not a public record that anyone could access. But Ms. Steinwerk, since you are a party, if you come to the courthouse with ID, you're going to want to ask for a copy of the hair follicle test results that were filed November 13, 2023. And then you can get a copy of that is what I'm being told.
Okay.
Okay. So I think what I'm going to do, because you have those future dates already set for trial, it doesn't sound like we need further review on this docket. So we'll just keep those January dates and see if he appears.
Is it documented every time that he doesn't appear?
Yeah, in our clerk's
Okay.
notes. So when you go in front of, your next thing will be, I just had it up. Let me get back to
January 10th, I believe.
Your pretrial management. And I believe that's with Judge Bassett. When you go in front of the judge, yes, Judge Bassett at Judge Evans at 9 a.m. When you go in front of Judge Evans, he will see in the clerk's minutes from today's notes, it'll say parties present and parties absent. And he will see that Mr. Olson was not here.
Okay.
Okay.
All right. Thank you so much.
All right. Thank you. Okay. So Mr. Olson, when we were here last 2 weeks ago, I did advise you about the screening line. And you also had talked about perhaps reaching out to Mr. McCreary regarding payment. Where are we at?
I got a $1,500 HARP, approved for the $1,500 HARP. I think it's a grant, through through CORE, my treatment facility. And I'm also getting coordinated entry. Now this is new to me, so bear with me. And her name's Whitney Roberts, and she's got me, it's the TBRA voucher program. And also I'm working with Jacinta down at CAP to hopefully get my back rent and a few months forward rent being paid. I know those are just words, but there's light at the end of the tunnel. And I did talk to my landlord, not just the secretary, but the head. I can't think of her name right now. So she's aware of what's going on, and we're just kind of playing that waiting game. They're really backed up, and I haven't got to see Jacinta. I have another appointment with her, and so we can move forward. So I really don't know if what I'm doing, like representing myself, or if Whitney or Jacinta from CAP are going to step in and let the court know what's going on.
They will not. So when we were here last, I asked you to reach out to the eviction screening line if you wanted to be represented. Did you do that?
No.
Okay.
And have you reached out to Mr. McCreary about these payments that you say are in the works?
I haven't reached out to any of these attorneys. I've just been working with, like I said, like the people at CAP and the people at CORE trying to get approved and getting these matters handled.
Do you have any documentation about these promised payments that you're talking about?
Well, the $1,500, that's absolute. I think that New Springs already got that. That was in the makings last Friday. It got approved. So they should have received that throughout this week. And I do have some paperwork on this coordinated entry program that there is. But like it doesn't really say how much they pay it's based on my income, and then they take care of the rest. And I'm really new to what's going on with it, so I really can't explain that much. Now I have a 10 o'clock appointment down at CORE today, and Whitney has been sick this week, so I didn't get to see her yesterday. So I'm kind of just in the loop waiting myself, but there is good light at the end of the tunnel, is all I can say.
Mr. McCreary, go ahead.
I guess this one's a little different because there was no representation anticipated or pursued. My understanding was he was supposed to reach out to my office. We didn't receive any communication from him, as he stated today. I didn't know about the alleged $1,500, but whatever the case, his rent arrears at this point are $4,500. And as we go, it just gets more and more expensive while Mr. Olson fails to pay the rent and fails to take the action that the court directed him to. So in light of that, I'm requesting that the court sign an order for the writ.
Yeah, and it's my understanding, but correct me if I'm wrong, since I don't deal with the after effects of signing the order, is it 5 days before they will enforce it? If I sign it today, when does that go to the sheriff?
Generally, it's taken to the sheriff today. They go out and they serve it or post it, and I believe it's a 3-day period after that before they can execute. But as a practical matter, it's always, I'd say at least 5, if not almost always 6 to 7 days before.
Yeah.
Your Honor.
Go ahead, Mr. Olson.
Is there a way that I can, like when I leave here, go have somebody call Mr. McCleary and let them know what, like I can go to my landlords and talk to her and give them some like positive feedback on what's going on, so I don't have the sheriff get involved?
The only thing I'm willing to do for you is, while we're on docket, if you can provide some sort of proof that payment is in the works right now, like in the next 45 minutes.
Okay.
I would take that into account. Although, Mr. McCreary, how long are you here with us?
Hopefully I can do my last matter here in a minute, and then I am in district court at 10 a.m.
Okay.
Is there a phone number I could have them call him to let somebody know? Like,
who call who?
Well,
I'm not sure what you're asking.
Whitney, the lady that is working with me for my for this housing program, this coordinated entry, she's the one that cuts the check to New Springs, the $1,500 HARP grant that I received. Just so somebody can let him know that I'm not just that those aren't just words. So
Mr. Olson, the problem I have is that 2 weeks ago, a couple of problems I have. One is there's rent owing for April of 2023, August of 2023, September
of 2023, November of 2023, and now December of 2023. So this is a case stemming with back rent all the way back to April. So here we are in January, and 2 weeks ago, I very specifically, and reread my notes here, implored you to seek an attorney through a free eviction defense screening line. And you did not do that. And I said, or alternatively, please be in discussions with Mr. McCreary about this money. Here we are now, and you're telling me these things, but I have no proof. I have no documentation. My hands really are tied. I am going to sign the order for writ today, but Mr. Olson, what that means is you have a few days still before they would enforce an eviction, that if you do truly have those things in the works, get that information to Mr. McCreary's office today.
Okay.
Okay.
I wish you knew the stuff I was going through right now. I'm waiting for.
I do understand, but, and that's why I implored you to seek an attorney like you saw the first two individuals on this docket did on December 22nd. So you still can do that. You still can do the eviction defense screening line today. But I am going to go ahead and sign the order for writ because I think it is otherwise appropriate. All of the service has been proper, and you still have a little time to work this out, but don't wait.
Okay.
That should be your job today. Okay.
It is absolutely.
All right. Thank you. Oh, go ahead.
My office closes at 3 p.m. on Friday.
Okay.
So today it's closed at 3.
So yeah, Mr. Olson, I'm not sure if you could hear that, but on Fridays, Mr. McCreary's office will be closed at 3 o'clock. So if you want to hop out of the iPad booth and start working on some of this information now, and then call his office before 3 o'clock, I would say before 2 o'clock. So he has time to follow up with his client on any information you give him. Okay.
Absolutely. Thank you.
All right. Thank you, Mr. Olson. You're free to hop out of the iPad booth.
Okay.
All right. With that said, I'll call the next matter, which is Christopher Olson and Tiffany Johnson. This is cause number 14-3-510-0. And let me just pull up my notes and then we can get started. All right. So first off is Christopher Olson either present in the courtroom? Yep. Yes, all right. Good morning, Mr. Olson. Come on up and take a seat, whichever side you want to be on. No preference on my end. And then Tiffany Johnson, are you on the line this morning?
I'm here.
Okay. And I see that your name on the Zoom is Steinweg.
Yes,
Okay.
that's I'm married since we began this case.
Okay. All right. So I'll refer to you as Ms. Steinweg and then Mr. Olson. Okay. So we're here today for a pre-trial hearing in preparation for a trial that is set for the 29th of January of this year, so the end of this month. And so generally with a pre-trial, we try to make sure that all parties have all the documentation from the other side, that the other side says, hey, at this trial, I'm going to bring in these documents and I want the court to look at these documents. And generally beforehand, we share those documents with each other so everybody has an idea of what's going to be presented. It's also an opportunity at this pre-trial to make sure we know how many witnesses are going to be called, who those witnesses are, their identities. And so we try to share that information here also. And just in general, just try to make sure that everybody's prepared for the trial. And we can talk about procedure. If you have questions about, how does a trial roll? What are the steps involved? We can certainly talk about that here today. But that's the general purpose of our pre-trial hearing today, is to get ready, make sure everybody has all the information that they need to have in preparation for the trial, and kind of answer some of your questions as far as expectations or the procedure that will be followed at the trial. So maybe we could just start with both of you and just asking, maybe I could just ask Ms. Steinweg, as far as witnesses, what witnesses do you plan to call during the trial?
When I turned in the paperwork, I didn't put any witnesses.
Okay.
Down.
So am I correct in assuming that you plan to testify and present evidence?
Yes.
Okay. And then any other persons that you think you may potentially be calling?
No.
Okay. And then a similar question to you, Mr. Olson, as far as the trial, what witnesses do you anticipate calling?
I don't have any witnesses, Your Honor.
Okay, so and I assume that you would be presenting and testifying?
Yes.
Okay, all right. And let me ask the parties as far as what are the issues, the main issues that you're concerned about that you want the court to hear about and rule on, Mr. Olson?
I guess that when we got the results from the hair follicle, it went back to where I got clean in July and put myself into treatment, and like I was kind of confused how the other judge reacted, like that it was like I was dirty then, but I wasn't. And, you know, since that time I had gotten myself into outpatient treatment, and I also got myself into a mental health counselor, and was, you know, getting all back on the right track. And I just kind of took the wind out of my sails. I hope the court, you know, looks at that and takes that into consideration. And I know that I didn't get my paperwork, I guess, turned in on time, and I was missing 1 0. So the other judge couldn't take my paperwork, but we've fixed that, and hopefully it's I did. Now I texted Miss Steinweg the copies that I have that I turned into the courts. I hope that that's okay.
So what are those copies?
There's 2 pieces of paper from my treatment facility, and there's 1 from my mental health facility.
Okay, all right. Okay. So it sounds like that the things that are important to you, you're talking about some substance use disorder or drug and alcohol evaluations and hair follicle tests, and also some mental health evaluations and treatments, and I think all those would be relevant for the issue of parenting plan. Is parenting plan at issue?
Yes.
Okay, and is child support, does that need to be decided also?
I don't think so. I'm behind on that. I lost my job in last December, like over a year ago, and I've been waiting for disability. I got diabetes, and it really messed me up, and I'm unable to work at this time. So I've been waiting to get the disability going on. It's kind of been a nightmare.
Okay. All right. Thank you. I appreciate that input. Ms. Steinweg, as far as the issues that you feel that you'll be presenting and talking about at the trial, and you want the court to rule on, what are those?
It's definitely the drug use and the amount of time that he is spending with his son. We have a temporary parenting plan in place currently, and he is supervised by his mom, or Chris is supervised by his mother. And my son says that he's only even showing up for 2 hours a day to see him. So
that's not true.
It's the drug use.
No, we're not going to decide the issues today.
The parenting plan change. As far as the child support, he's over a year behind, but I have contacted the Division of Child Support, and that's through their office now. And also there's some medical bills that have been my son got a concussion while he was at his dad's, and in our parenting plan it states that he will pay a portion of medical bills, and I don't know how to go about that either. So
okay. All right. So it sounds like both parties are apprised of kind of the main issues. There's a parenting plan is at issue, child support is at issue, and issues that impact those particular areas. So generally, if you have documentary evidence that you want the court to consider, you can do that in one of two ways. One, you could take a look at, you can Google this, you can look up ER 904, Evidence Rule 904. That's a rule that you can utilize to present evidence, and you can submit it to the court. If you submit it in a timely fashion and the other side doesn't oppose it, then that evidence is admitted into evidence. So that means the court will consider it. The other way to get evidence, documentary evidence into the court is to bring it on the day of trial and bring copies for the other side and for the court. So if you have documents that you want the court to look at, bring 2 copies, and then we can talk about that. So that's kind of the general contours of the issues that we'll be addressing. So it's a good idea to maybe write those things out, or at least have the highlights of the particular items that you want to cover, because sometimes when you get at the day of trial, it's pretty stressful and you forget things. So if you make sure you write down, you kind of have an outline of the things that you want to cover and talk about, and be prepared to present that. Generally during the trial, we start with an opening statement. Opening statement is just say, hey, this is what I think this case is about, and this is what the evidence is going to show. The petitioner will go first. So Mr. Olson, you would be the first person to go with your opening statement if you want to give one. And then if Ms. Steinweg wants to give an opening statement, she can give hers. And then after that, then we would turn the time to Mr. Olson to call your first witness, which it sounds like it would be you. And you would call yourself as a witness, and then you could share the information that you want to share. After you've shared that information, Ms. Steinweg is permitted to ask you questions about information that you've presented. And then you can also give additional information after she's questioned you. And then we give her another opportunity to ask you questions. So that would be your testimony. And then if any other witnesses that you want to call, you could make sure that they're here on the morning of the trial. And then you could go ahead and ask them questions that you feel supports your position. And Ms. Steinweg would also have opportunities to ask them questions. In like manner, once you've finished presenting your testimony and your case, then we turn the time to Ms. Steinweg for the calling of her witnesses, which I assume would be her, and then any other witnesses that she would like, and you'd be permitted to ask her questions and any of her witnesses' questions. During when it's your turn to present evidence, when you're testifying, if there's documents that you want to present and you haven't done that ER 904 process, then you could just say, Judge, I want you to consider this. I want to admit this into evidence. I want you to look at it and think about it and be part of your decision. So you can present that during the trial. And again, if you have need to have copies for the other side so they can see what that document is. After you've each called all your witnesses and testified and presented whatever documents or other evidence you want to present, then we go to closing argument. Closing argument is just a fancy way for you to argue your case. Basically, this is what I heard during the trial, and this is what I want, and based on the evidence presented, this is why I should get it, and that's why this is why you should rule in my favor. And after you've given your statements or your closing arguments, then the court will either do one of two things. One, it'll give you a ruling right then and there. They may take a brief recess and come back and give the ruling, or they may take it under advisement, which means that they would either write out a decision or have you come back at a later date and they'll give you an oral decision. And after that's completed, after the decision is made, then there would be orders that would be prepared, basically orders that summarize what the court ordered. So if the court would verbalize X, Y, and Z, this is the parenting plan, this is child support, then that would be documented, and everybody get a chance to look at that proposed order, make sure it's correct and accurate, and then that order would be signed and filed, and that would conclude the case. So that's kind of procedurally an overview of the case. Ms. Steinweg, Mr. Olson, do you have any questions about that, the general procedure of the trial?
No.
Okay.
Am I able to call my husband as a witness?
You're welcome to call any person as a witness that you'd like.
Okay.
Your Honor, what was that called? The ER 904?
904, Evidence Rule 904.
Okay.
Yeah.
And then a question about so she's saying that, Zach's saying that I'm only coming over for 2 hours. I would not like to bring my mom into the courtroom. Could I have her maybe write something out saying, I guess, how many hours I've spent a day?
Yeah, as a general rule, the court prefers live testimony, and because we can see mannerisms, we can see the manner of presenting the testimony. And generally, if somebody writes a statement, it's hearsay. It's an out-of-court statement offered to prove the truth of the matter asserted. That's kind of the legal definition of hearsay.
Okay.
So generally, if you want somebody to testify or share information with the court, they have to do it in person.
Okay.
It's a good question. Ms. Steinweg, do you have any questions?
No, as far as the readiness hearing, what happens there?
The readiness hearing, which will start on January 24th at 11:30. Basically, that's the final call. Like, is everybody ready? Great.
Okay.
And then it'll just be a confirmation everybody's ready, that we'll be here on the 29th of January at 8:45 to do the trial. So the readiness hearing will be the next step to make sure that everybody's ready to go, so we don't lose a court day.
Okay.
Mr. Olson, any other questions?
I don't think so.
Okay, Ms. Steinweg, any final questions?
No.
Okay, thank you both for being here. We will
Thank you.
we'll next reunite on the 24th of January at 11:30. Okay, thanks.
Thank you.
And then Olson and Johnson, 14-300-5100.
Yes, ma'am.
All right. And I have this as a one-day trial, and I'm assuming in the booth is Mr. Olson. Okay. I have this listed as a one-day, is that correct?
Yep.
And is there, Mr. Olson, you're muted, so I'm going to just hit this button that says ask to unmute. So if you can click the unmute there.
Okay.
Perfect. Okay. We have availability Wednesday or, well, how about Thursday next week? Does that work? The 1st of February?
Okay.
Your Honor, I would hate to do this, but I've been going through an eviction process, and the sheriffs were going to be at my house to put my stuff in the road tomorrow. And yesterday, finally, my paperwork went through. I got cleared with CAP to get my rent taken care of, and I haven't had any time to really put in on this case, and I don't want to waste anybody's time anymore. I was going to ask if I could get an extension by chance.
May I say something?
You may, just give me one moment.
Okay.
Here, what, okay, I just wanted to look at some of the history of the case. And so I have in the court file here, I have you as Miss Johnson, but you're Miss Steinweg. Is that correct? Yeah. Okay. Go ahead and respond.
This court case has been going on for almost a year. Mr. Olson has not shown up to at least 5 to 6 court appearances. The most recent in December. I think that this has been going on long enough and that my son deserves an answer of what's going to happen.
Mr. Olson, anything else?
Oh, it just, I know it really doesn't matter, but all the stuff that I've had going on in my life, I know that I haven't missed that many court dates, 2 of them. And you know, I just haven't had time. Like I said, I've been going through this eviction process along with some crazy medical stuff, and I would just love an extra week or 2 to better prepare myself.
All right. I'm looking through the court file here. Just give me 1 second. All right. So there was an adequate cause decision that was found back in June of 2023. So we're about 7 months out from adequate cause. There's temporary orders in place. It looks like that were just entered after a suspension in visitation occurred in November. And then an amended visitation set November 22nd. There was a notice for this to go to mediation for a 3rd mediation. Did that occur?
No.
The judge canceled that because the mediator, both mediators and I signed that he agreed to visitation supervised. And then the next day we had court and he said he never agreed to it. So the judge said it'd be a waste of time because we're going through hours of mediation. And then the next day he says he didn't say that. So.
Right. All right, well, we were here last, it looks like on the 10th of January, and in front of Judge Evans, there was a discussion about what would occur at trial, whether there would be any witnesses, what specific issues were to be addressed at trial. And I will note that this case, while it's a 14 cause number, it appears as though it was March of 2023, and a motion for adequate cause was filed. So we are getting up there as far as the amount of time in this case. What I am going to do is I'm going to set this for next Thursday for trial. Mr. Olson, if you feel that you are unable to prepare adequately within the next week, you can always raise your motion again to the trial judge. But I'm going to set this for an in-person hearing Thursday, February 1st, 2024 at 9:00 a.m. And the docket that will come out the day before will tell you which courtroom that you're in.
Okay.
Okay.
That'll be set for one day.
Thank you.
Thank you.
All right. Thank you. And that handles everything, so we can go.
All right, so do we have the Olsons? Mr. Olson, do we have Tiffany Olson there? Okay. And I know my investigator, Ms. Schaefer, is, excuse me, on the screen right there. So did you folks receive a copy of Ms. Schaefer's report?
Yes, I did.
Did you receive that, sir? I did. Okay. So this is essentially a continuation of a trial that we heard some time ago. Looks like we did that on February 1st, about 2 months ago, a month and a half ago. And it appointed Ms. Schaefer to look into this and receive the report. And so let me just get myself back up to speed here. We did not do, we did an order. Okay. Want to make sure where we were at. All right. So I guess you two tell me what your feeling is about this recommendation, which just in summary, provides a little different approach than just the modification that we were here about. So,
You want me to start?
yeah, I think, yeah.
I feel like this would be a step forward. I don't know how you would go about the UAs. It seems that he stated at our last court date that he was clean since July, and that's clearly not the case. So I think that this, if he has a certain amount of time, being able to get a certain amount of visits back would maybe give him some motivation to stay clean so that he could spend some more one-on-one time with Zach.
Let me see here just a second. You're still working through the methadone program?
Yes.
Okay. How's that going?
It's going fine. I kind of actually like stepped it up and requested one-on-ones, not on the phone, but at the facility with my counselor, and to try to get more involved.
Good. So, Ms. Schaefer, did you have any comments about your report that might be helpful as far as your recommendations at this juncture?
Clarify that when Mr. Olson starts working that.
Not hearing you very well. You might not have the mic real close.
Can you hear me now?
Sort of.
How about now?
There we go. That helps a bunch.
I just wanted to clarify that when Mr. Olson starts working towards earning that time back, that I hope that his mother is still open to allowing Zachary to go there for the whole weekend so that he's still in his dad's presence, but his dad will then start earning those rights back. It wasn't real clear in my report. Mr. Olson does seem to be making the right steps to getting clean, and it does seem that Zachary is a good motivation for him. I just worry that I don't want Zachary to be the only motivation for him.
Do you have any, assuming he's continuing in the program, which is essentially it's an MAT type program with the methadone, as long as he's in compliance with that program, do you see that as a barrier?
I don't see that being a barrier, no, especially if he continues to do his mental health counseling separately in conjunction with that through Core Health.
It's the other stuff that was in there that makes me nervous. So, okay.
And then I think Ms. Johnson also had a concern, and I really didn't follow up on this. I did have a hard time getting some answers from Mr. Olson. She was also concerned whether or not he had legitimate and legal driver's license and insurance. But I don't believe that Mr. Olson is transporting the son at this time. So, and that can change at any given moment as well. But I do know that was a concern for her also that she would like to address.
You have a driver's license?
Yes, I do.
And car insurance?
Yes, I do.
And do you have that with you?
I've got my driver's license with me. Okay. Would you like to see it?
You want to take a look at his driver's license? Or
Well, I mean, he's not gonna transport right now anyways. It was a concern because if he's unable to pay his regular bills, then I thought maybe insurance might be put on the back burner. And I just want to make sure that Zach is transported, you know, by Kay or us, so that.
Good afternoon, ma'am. How are you today?
Good.
So when you were here the last time, I asked you if you were willing to continue doing what you're doing for a while. Are you still in a place to do that? That's an imposition on you, obviously, and the only way it's going to work and make everybody feel comfortable with this is if you're still willing to do that.
No problem. He's been in my life 14 years of his.
Okay. Well, when I look at this is I guess what you'd call just kind of a step type of program, which requires you to do the stuff you're supposed to do, provide the UAs as requested. And again, I think as long as you're enrolled in the methadone program and you can provide, say, a monthly report that you're in full compliance there. There's a lot of folks that, I mean, they work regular jobs or out in the community that are on methadone. That's been around since the 60s when people came back from Vietnam. Methadone can be a problem, but if it's that's a monitored program, as long as that's the only thing showing up and that he's in compliance with his treatment there, that's not a huge concern for me. They may place limits on you driving with that. I don't know. Typically not, but they could. So you need to make sure you're in compliance with that. But so when was the last clean UA we had other than the methadone? Do we have that?
In her results, it says that 2/21, it says that he's failed all December, January, and 2/21 tested positive for fentanyl.
Okay.
Your Honor, the last report was, I think, in November that he had a clean UA. And then according to Mr. Olson, when he learned that he wasn't going to get visitation, he unfortunately went the wrong route and had a slip up. And it just seems like he's had a hard time getting back to that right mentality.
So as of right now, we don't have a clean UA?
No, not at this time. I have not seen one.
Okay. If you took a UA today, would it be clean, sir?
I don't know how long that fentanyl stays in your system, and the last one that I had that had come up positive, I was really surprised that it would. I think I would come up clean today.
Well, this recommendation would be about a month and a half after you provide a clean UA. That would be nothing but methadone, so long as you're in compliance over there, before you could start progressing through here. This seems like a pretty solid recommendation, frankly. It's gonna provide you with at least some comfort that he's not using other stuff. Methadone, if it's not being abused, again, it's a maintenance kind of drug. It's almost, I mean, it's, like I said, there's a lot of people working fairly high level jobs that take methadone on a regular basis. Unfortunately, that seems to be one of the treatment methods that we use, but it is there. So,
Your Honor, I don't plan on staying on that. I plan on weaning off that as soon as I can, actually.
good. Well, and so you may want to talk with your doctor. There's a few other things. There's a drug called, I believe it's called Vivitrol, which is a non-narcotic type of drug that helps eliminate some of those cravings. It's an expensive drug, which is one of the problems with it. So depending on what your resources are or what insurances you may have available, I don't know, it may be better than it used to be, but that's another option. So you may want to talk to somebody about that.
Okay.
It's a blocker that takes away your craving. So methadone essentially is a replacement drug. So you're still getting a feed from that. So, but we got to get all the other stuff out of there.
Okay, we're gonna be.
Okay. So in the meantime, I don't know if we want to just set another review out of ways and see how this is going.
I would, yeah.
Is that
I
what-
would be in agreement to that at the
Okay.
45 days or month and a half or.
Okay.
And with a clean UA and move forward.
So why don't we do this? I can just do another order that essentially adopts these recommendations going forward. We both got a copy of them, and I could set a hearing, let's see here. See here. I need to check and see. I'm going to be out of the area a few times coming up, so I got to make sure it's a date that I'm here. So if we were to go out, so let's say to about the 16th, that looks. Let me just check here. I think it may be May before I'm. Okay, so we need to go. Give me just 1 second here. I got to check one thing. I have a couple of things I have to go to that are going to take me out of the area. So, oops. If we were to go the 16th of April, that's 6 weeks out from today. Does that work for both of you?
Yeah.
And I would just put it on this docket. So we just put another review on, and I could do an order that adopts this recommendation.
1 p.m.
1 p.m. And I put you on the end of the docket in part because I didn't know how much more we had to do on this. So I didn't want to try and do a trial if we had to do any more work on that. But if we set a review, I'll try and get you guys in and out real quick if things are going well.
Hey, can I
So-
ask 2 more questions?
Yes, ma'am.
Will that just be 1 test, 1 UA for that day, or is
No, I'd
there a
wanna-
way to know that he's been clean for those 45 days?
If we think are you taking regular UAs with your treatment?
Yeah.
Okay.
But
How often?
they're just kind of random. It seems like I should be getting a little bit more, honestly. It seems like I only get like 1 every 2 weeks, it seems like.
Okay, that's not abnormal for treatment programs.
I'm
So
wondering if I could maybe ask them if I could get at least 1 a week, or, because I've talked to my counselor about what's going on right now,
If they're able to do that and then get a copy to you as well as to the court, that would be helpful.
Okay. Yeah.
Yeah. So, I mean, really the goal here is to get you clean so you can be part of your kid's life.
Absolutely. Thank you.
And I'm glad that you're participating. That's a good program over there. So, so we should have 2 or 3 UAs over the next few weeks, and 45 days means if you got 1 dirty one, we start the clock over.
Gotcha.
So
not gonna happen.
Okay, good.
And then I had one more question
Yes.
regarding spring break. The current parenting plan says Thursday through Thursday, and that was based on a Monday through Thursday school schedule. So I was just, Kate, or they have Zach, the 22nd, 23rd, and 24th, and that's the week of spring break.
Okay.
If we could just transfer on Wednesday so that you guys could have them additional, would that be okay?
Yeah.
You'd have him half the week and then
Yeah.
I'd have him the other half. I just
Yeah.
wanted to make sure it was.
Well, here's the thing, if the two of you come to an agreement, or the three of you, that you want to adjust something for a particular day or a week or something that, I mean, something's coming up and you want to work around something, you're free to do that. Don't feel that you're not getting in trouble with me if you come up with an agreement, we're going to do something different this week because,
Okay.
botany day or something.
Yeah,
Okay.
because I was,
So, yeah, you're not going to get in trouble here as long as you're doing it by agreement.
okay.
So however you handle spring break is fine with me as long as you're both comfortable with it.
All right.
Okay.
I am
Thank you.
like questioning the transportation. I'm feeling a little guilty that that they're having to do all the transport.
As long as
Well,
Zach's safe, that's what.
Yeah, once we get you clean
Okay.
and we get you past this, but 45 days out, we'll take a look at it. I think you should be doing some of that too, obviously, but let's get you to the place where everybody's comfortable with that.
Okay.
So, all right, so we will see you, what did I say, in April
16th.
April 16th.
Thank you.
All right, we'll see you then. Keep up the good work at the treatment. That's very important. All right, so I believe that we have the Olson and Johnson matter. Good afternoon. Good afternoon. All right, and I have not heard any additional, how are things going?
There's one thing that I would like to request in addition to his supervised visits every other weekend. We didn't address sports events or school events.
Let me take a look here. Just going back to the recommendation that was filed by Ms. Shaper. And I see Ms. Shaper is present on Zoom. I don't know if you can hear us.
I can, Your Honor.
Good afternoon. So this is the Olson and Johnson matter.
Yes.
If you could restate what your concerns were.
I just wrote something up real quick just because I'm so humiliated by the last school event. I'm requesting that Chris also have supervised visits by Kara Lloyd when he wants to attend any sporting or school events until he has 6 months proof of clean ways. On April 9th, Chris showed up to Zach's track meet unsupervised. He approached Zach on his own numerous times during his meet. I called Kay and asked if she was at the track meet. I then said that I didn't know Chris should be there without her or Lloyd as it wasn't approved by the court yet for him to see Zach besides every other weekend. She said that she would talk to him and we could find out at court what to do. Please keep in mind, I did not approach Chris on my own. I discussed this with Kay as a middle party. Chris then approached me as I had my 1-year-old in my arms saying to call the cops over and over. As I continued to try and walk away, he was continuing behind me and proceeded to call me a effing weirdo over and over. I continued to walk away until he stopped. I then walked my daughter's.
Objection. Can I object to this?
This is exactly what happened.
Okay, well, I think what we probably need to do, and this was really a review today. I think that's what it would probably be useful to do would be to have you put something in writing.
Okay.
And file it with the court.
Okay.
Send a copy to him. He can respond to that, and I can put this out a couple of weeks. And I mean, you're under the same the recommendation from Ms. Shaper.
Is every other weekend supervised?
Right, so that's what you need to follow, sir.
Yeah.
So am I allowed to go to his track meets?
I assume if you're just watching, that's probably,
Yeah.
you have an objection to that if he's just watching?
The problem is he isn't just watching, he's
No, that's not-
approaching
that's
Zach
not correct.
and
Well, hold
he's
on, sir.
approaching me and
Incorrect.
humiliating me and following me and calling me names.
Total objection.
Okay, well, hold on.
Out of line.
Okay, I'll let you file with your concerns. And if you're gonna be anywhere around any sporting events, you need to stay away from her state, then you can watch at this point.
She's
Sir?
saying that I approached her.
I'm not-
That's totally incorrect.
Okay, all I'm saying, well, I'll see what you both have to say, but I want you to submit it in writing so that you both can look at what you're gonna say ahead of time.
Okay.
And I can put this out and come back on the 7th, which will really, unless you think you can be ready before next week.
The 7th is fine.
So the 7th, which is 3 weeks from today. So what your concerns are, your requests, I'll take a look at it and we'll go from there.
And what's the paper that I file?
This is a declaration.
Okay.
And it would be under oath, and then if you can file that with the clerk, and then I'll take a look at those when we come back on this before the 7th, and we'll address whatever issues that we need to.
Okay. And have any clean UAs been turned in, or?
I do not have anything at this
Okay.
point.
They're,
So
they're
we're
getting
still-
ready to start coming in, that my treatment facility is so,
Okay, well, if you have those should be filed with copies to her. Okay,
Okay, thank you.
right, so we'll set this over to the 7th for review and status on everything.
And that's at 1 o'clock.
Be at 1 o'clock,
Okay.
correct.
Thank you. Am I able to do it online through Zoom?
You certainly can.
Oh.
Yeah, you certainly can. And there's a link on our website to get to that if you want to
Perfect.
review Zoom. So we'll come back and we'll take a look at it in 3 weeks.
Your Honor,
You are welcome.
I didn't quite catch that. If I'm not allowed to attend the track meet though. That's
At
hard
this
enough
point,
to
just
get to his events since they're
at this-
so far.
Okay,
away.
I can't talk to you about your case with her gone,
Okay.
so.
I got you.
Just
Okay.
all, okay, we'll come back in 3 weeks and take a look
Thank
at it. All right, I believe that is, you're welcome. Mr. Olson. And do I have Tiffany Olson? Tiffany Steinweg.
I'm here.
There we go. All right, so I believe this is our last case. This was our ongoing trial review from some time ago. And I know there was some issues that were brought up the last time we were here, Miss. Let's see here, just a second, it's loading slowly. So, Mr. Olson, did you get a copy of the declaration she filed?
No, I haven't, Your Honor.
I didn't serve him with it.
Okay, he kind of needs to have that so we can,
Okay.
we can talk
I'll
about
have
it.
the police department serve that to him.
Okay, can we just give him a copy out of the clerk file? Can we do that? It's in order or not? That was her declaration. Is that something we can do? Okay, how much does that cost? Okay. So it'd be about $1.50. It's 3 pages, and you can get a copy here.
Okay.
So I'm gonna have him pick up a copy at the clerk's office.
Okay.
And then I can put this on for next week. And then he can take a look at it and I'll consider what your concerns are.
Okay.
Okay.
Has he turned in any paperwork or?
I've got some paperwork that I got from my treatment facility. Unfortunately, everything that seems to happen to me is taking forever. And since I'm doing good in treatment, they're only UAing me once a month. So I had to request that they put in once a week UAs, and they are doing that. And it's supposed to start this week, and I don't know what day. But I have a letter of compliance right here,
Okay, so what I want you to do is I want you to they'll give you a cover sheet at the clerk's office. I want you to file a copy of that and get a copy to her so she can see that you're in compliance.
Okay.
And then pick up the copies of what she's got, and then we come back in next week and we'll talk about all this.
Okay, when next week then?
Same time.
Okay.
At 1 o'clock. He's got a treatment report. He's gonna get that to you. Any problem with him having that delivered, or how do you want to do that? ma'am?
No, I guess my concern is we just keep coming back and it's the, 45 days of clean UAs and we haven't seen any yet. So I'm having to miss work and all this to come back and, like.
Well, I haven't seen the treatment report he's got, so I don't know what it says. It may be documenting that. I don't know what does. I don't want to take a look at it until you've had a chance to see it. So, I mean, I can set this out farther. I
I
can't.
would prefer that we set it out further just so that
Okay, that's fine.
unless he's stating that he has 45 days of clean UAs, it's pointless for us to come back next week because nothing's going to change.
You don't? Okay. So do you want to come back in 3 weeks or about a month, maybe?
Yeah, that would be great.
That work? Do you want the 28th of May or the 4th of June?
Let's do the 4th of June.
That work for you, sir?
Yeah, that'll work.
Okay, June 4th. Get her your documentation, and then if you get some updated documents, you need to get that to her as well as file it here. And then I'll consider all this, and he'll get a copy of this from the clerk's office, so you won't have to get that to him.
And I'll accept it via email if that's easier for him.
Okay.
Okay, that'd be good.
Okay, perfect.
June
Thank you.
4th June 4th at what time?
June 4th at 1 o'clock,
1 o'clock.
and it'll be towards the end of the docket, so if you're not here right at 1, you're probably just fine.
Okay, thank you.
Okay, all right.